Hi everybody, Dacob here. Welcome back to the Fashion Bunker. Hermes wins the lawsuit against Mason Rothschild, the artist who created the Meta Birkins. What happened? Is this really bad for artists and for free speech? Let's get straight to it. First, subscribe to my channel if you haven't already here on YouTube. You can also push the join button next to the subscription button. Become a member today. Gain access to extra perks. You can also join me on Patreon, superdacob, all spelled together there as well for extra perks. Thank you to my members and patrons who have already pledged. Now, let's get straight to it. Let me show you these Meta Birkins. Let me scooch over to the side so you get to see. This is a couple of examples of Mason Rothschild's, that's his artist name. Meta Birkins, he created these NFTs, non-fungible tokens that he sold of these kind of fluffy digital Birkins. They're not real material, tactile Birkins. They are digital NFTs. And so Hermes sent him a cease and desist the second that they saw this. This was in connection with Art Basel, I do believe. So I think he did have a representation in terms of like gallery or what have you, because it's kind of a big deal if you make it to Art Basel as an artist. But everything I say in this video is for entertainment purposes only, not rooted in truths or facts. Everything's alleged and just my opinion. So Hermes sends him a cease and desist. Mason Rothschild, Mason replies and says, no, I will not apologize. I will not stop selling these NFTs. This is art. He kind of, and I'm paraphrasing here, stated that this particular type of artwork was, and because it's even though digital but fur, was a commentary on animal abuse in the fashion industry and luxury fashion industry. So he kind of tried to pitch it and phrase it in that direction. Hermes then pursued by saying, okay, you don't want to cease and desist, we're taking you to court. And then they went to court in New York, and now Hermes wins the case. And let me tell you, I have here an article from artnews.com, and in which they state that Hermes wins lawsuit against artists whose NFTs based on Birkin bags were deemed not art by jury. So this is an interesting point, because technically what we were worried about as this thing was going to trial was that, oh my gosh, you know, our rights of free expression, of also as artists to express ourselves, is at stake here, because if the court rules in favor of Hermes, art is at risk. But there's the plot twist, or maybe they found a loophole. Hermes's lawyers found a loophole maybe, because this work was not deemed art. Hence why Hermes wins the case. Now, one of the first major NFT-related lawsuits was this one, believe it or not. And in the US, and the decisive loss for an artist as the luxury brand Hermes triumphs. Now, the company is now set to be awarded $133,000 in damages, even though Mason states that he made about $125,000 for the series in total, Meta Birkins, but Hermes estimates that the Meta Birkin series brought in an estimated $1.1 million. So in 2021, not long after the project was unveiled, on a dedicated website, Hermes did send a cease and desist. So this has been going on since 2021. Now in 2023 or late 2022, that was the verdict. Now what was fascinating to me is that the jury ruled in favor of Hermes, saying that, well, this is not art. Like, how can you deem this art or not art? Well, and then I kind of did a little bit more research. Also interesting that Hermes's lawyers, really sneaky. You know, okay, I have an issue in general when you're calling professional witnesses to the stand, you know, people who know their craft, and then lawyers try to block off witnesses. We've seen this also in the Amber Heard versus Johnny Depp trial. The lawyers really battle it out to get the right to get certain witnesses that are going to testify in their favor, probably, on the witness stand. Now, one particular witness was not allowed on the witness stand, Isn't that interesting? So this is also one of the reasons why people thought that Hermes was about to win the case anyway, because signs that the trial may be headed towards a win for Hermes arrived earlier in the month following up to the verdict of the trial, when the art critic Blake Gopnik, who wrote a biography of Andy Warhol, another artist who merged art and commerce, was not allowed to testify as an expert witness. So obviously he would have had a lot to say about the Meta Birkins and pop art and Andy Warhol and you know, the Campbell's soup. Andy Warhol also did the famous painting of the Chanel No. 5 bottle, Marilyn Monroe, and so on and so forth. But he was not allowed to testify. Now, then I was trying to dig deeper into what is this test? What test is this that deems if something is art or not? And we got the answer. It's the Ginger Rogers test. Believe it or not, Ginger Rogers many years ago sued a film company, production company, distribution company for having made the movie Fred and Ginger, or Ginger and Fred, even though she was not in the movie. You can check out that trial and how that went out. Anyway, she lost the trial. But what is interesting is out of that trial, what was born is the so-called Rogers test, which was allegedly utilized in the Hermes versus Mason Rothschild trial as well, to identify, to determine whether or not these Meta Birkins are art or not. So here's just 2 points that are interesting in connection to the Rogers test. It says it may be only applied to non-commercial marks, which determines that the title of an artistic work is protected under free speech from the Lanham Act when A, the title of the work has some artistic relevance to the underlying work. Now, we could debate that. I would say yes. The title of the work, the Meta Birkins, has some artistic relevance to the underlying work itself. Interesting that the jury, I do not know if the jury had to do this test or if the jury asked somebody else to do the test, and the results of the test came back. The majority of the test's results came back in favor of Hermes. So we have A, the title of the work has some artistic relevance to the underlying work, and B, and here's where I think Mason Rothschild lost, B, that the title is not explicitly misleading as to the source of the content of the work, which in this case might have meant, I'm just interpreting here, I'm not a lawyer, so obviously I cannot give any legal advice, I'm just interpreting what the text says. What I understand from this is that possibly in point B, whoever was questioned about these NFTs, the Meta Birkins, thought that maybe they were from Hermes, that Hermes created this project. So point B says that the title is not explicitly misleading as to the source of the content of the work. Now, if the people that did this test thought that the source of the content of the work was Hermes, in that case you lose. You see what I mean? Now, I don't know if both point A and point B have to be in your favor or if it's enough if it's just one. But that's it, you guys. I mean, it is kind of a sad moment for artists. And what this means, so basically the article proceeds by saying, what does this mean for NFT projects going forward? Remains an open question, although Rothschild's legal team presented the case as a potentially dire one for artists. One of his lawyers told the New York Times, and we quote, "Great day for big brands, terrible day for artists, and a terrible day for the First Amendment." So you guys, let me know what your thoughts are about this outcome of the case, of the trial, and if there's any more information that you wish to add down below in the comment section. Thank you so much for watching. Never give up on love and subscribe.